Hey everybody, it's your favorite red-bearded estate planning and probate attorney. How are you doing today? Today I wanted to talk to you about what should my trust own. But before I dive into that, I wanted to let you know how to reach out to me. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So, with that, let's dive right in. The answer is pretty much everything. You want your trust to have more than not. Because, as I mentioned earlier, there are so many times where I've run into clients who have a trust, they sign it, they think they're good to go, and this is actually a common problem for people who download trusts off the internet, but then they fail to transfer anything into the trust. So if you have a trust that is, if you sign a trust, it's worth the paper that it's on. That's it. The moment you sign it, it's worthless because it doesn't hold anything. So in order for you to actually have that trust come into effect, for the rules inside the trust to come to effect, you must transfer your assets into that trust. Anything outside of the trust, if it does not have a beneficiary designation, is going to go through probate, most likely. So what does that mean? In other words, I strongly recommend that you have two sides of your estate. You have one side, which is assets that have beneficiary designations. If they have beneficiary designations, as long as those beneficiary designations reflect what the trust says, then you're technically good to go. You don't have to transfer your assets into the trust. Sometimes you actually don't want to, and I'll get more into that in my next video. But at the end of the day, you'll want to make sure that all your beneficiary designations are good to go. If they are good to go and they reflect what the trust says, if your trust says 50% to A, 25 to B and C, then make sure your beneficiary designations say that as well. However, for your other assets, the other side of your estate where you have non-beneficiary designations accounts, or assets, then that's where you want to make sure those assets get inside the trust. So, more specifically, the most important one that comes to mind immediately is the house. You want to make sure that all of your real estate gets transferred inside of your revocable living trust, because 99.9% of all houses in Texas have no beneficiary designations on them. So, get the house in. Get all real estate. That includes rental properties. Rental properties might be a different story. You should consult your attorney by case basis. But definitely your primary residence, you absolutely want to get inside your trust. Other things are including your accounts that don't have beneficiary designations. You want to make sure that your personal effects are specifically allowed inside your trust. Make sure your trust says all my personal effects are effectively in my trust immediately upon signing this document. Personal effects, for those who don't know, are like jewelry, furniture, silverware, books, stuff like that. Other things that you'll want to transfer in, you technically can do cars. Cars are really not that big of a deal in Texas because it's very easy to transfer them through the DMV after you pass away, so I wouldn't sweat it too bad. But there are other assets like land plots, boats, anything that has a formal title to it that does not include a beneficiary designation should absolutely get transferred into the trust. So that's a mixed answer, and I apologize if it sounds a little confusing. So I'll reiterate. If the asset does not have a beneficiary designation, you should strongly consider, and you definitely ask your attorney, do I need to transfer this into the trust? Most likely the answer is yes, and most likely there's a very simple solution to just transferring that asset from your right pocket into your left pocket, from you as an individual to you as the trustee of your trust. There are specific phrases you need to use whenever you transfer assets into a trust. And that includes saying that you are the trustee of your trust, the full name of the trust, dated, whatever. So, for instance, if I'm transferring my house to me in my trust, I'm going to say Derek as an individual is transferring this asset into the trust. The trust is going to be I apologize. From Derek as the individual to Derek, the trustee of the Derek Christensen Trust, dated January 1st, 2023, or whatever. You need all three of those parts. You need the trustee name, then full name of the trust, and the date. You must have that on all the documents that you are signing to transfer the trust or the asset into the trust. So that is my recommendation. Everything that doesn't have a beneficiary designation, you should strongly suspect and absolutely verify how to get that inside your trust. This includes company shares, real estate, sometimes cars if you're getting frisky, boats, assets like fine artwork with titles to them, cryptocurrencies, everything you can think of, try to pull that off. And you should work with an attorney on that front, because in Texas, there are often times where you're not allowed to file, like for instance, you're not allowed to, as an individual, file your own deed that you drafted into the county record. You have to actually work through an attorney or a title company or some kind of formal professional service because they'll verify that the deed was done correctly. So at the end of the day, you're kind of stuck. You can't just download a trust off the internet and then just assume you're okay. You actually have to transfer things over, and you're going to have to work with an attorney anyways. So I strongly recommend just measure twice, cut once. You really don't want to mess around with this, because if you mess something up, then everybody starts getting into a hissy really quick, and a lot of bad things can happen. Because I could say, oh, you did transfer it, and then somebody else could say, no, you didn't. I'm going to sue you for that, and money starts stacking up into lawyer pockets real quick, and everybody loses. So all that is to say, again, if the asset does not have the beneficiary designation, try to figure out how to get it into the trust. Sometimes you don't have to, but most of the time you do. So with that, if you do have a beneficiary designation on that asset, make sure it's up to date and it reflects what the trust says. That's the general rule of thumb. If you need more specifics, I have memos, I have information that I definitely can help you out with. The next video is going to be about retirement accounts specifically, because they're unique themselves. So just let me know how I can help you out. Email me directly, Derek, D-E-R-E-K, at legionlawpllc.com. Or you can find me on my website, www.legionlawpllc.com. So with that, have a great day.